Alright, so we're here to talk about voidable transactions with a liquidator and a lawyer. We're going to talk about the history, we're going to talk about the defences to a liquidator, we're going to talk about some practical issues that we see when liquidators pursue these things.
So just the history of the voidable transaction regime. The history goes back an awful long way, all the way back to 1571, when there was a problem where people with assets were gifting their assets away, particularly to the church, to avoid creditors coming after them. And so Queen Elizabeth first passed a law to say that if you entered into a contract for the purpose of defeating your creditors, the courts could ignore that contract. In a modern setting, that law has been passed down to us in the voidable transaction regime. And the philosophy behind the regime is that the courts and Parliament don't want a company director to be the one who decides how the assets of his insolvent company are paid out. So you have a situation where a company director may have $100,000 worth of assets and $1 million worth of creditors. That company director can take his $100,000 and pay his favoured creditors. And quite often the creditor he chooses to pay is people he might have a personal guarantee with. So that's the purpose of the insolvent transaction regime, is to claw that $100,000 back, so all of the creditors in insolvency can get 10 cents in the dollar. But the regime has a two-step process. So in the first instance, for a transaction to be declared insolvent, the company must be insolvent at the time that the transaction occurred, and the creditor who received the money must have received a preference ahead of other creditors. But just because a transaction is insolvent doesn't mean it needs to be paid back. So how would a creditor avoid having to pay back the money?
Yeah, so a liquidator can look at voiding transactions for 2 years prior to liquidation, and so it's a long period of time. So the defences for a creditor here are that they act in good faith, they didn't suspect insolvency, nor would a reasonable person, or they gave value or altered their position. They need to prove all three to be successful. So practically most cases fall down to suspicion of insolvency. Most creditors acted in good faith and they gave value. So giving value is providing goods or a service and then they got paid. So as long as a creditor can prove all three of those grounds, then they will be successful against a liquidator's claim.
So one of the things that we look for as a liquidator, we don't always have all of the books and records of the company. So quite often we need to try and work backwards. And if we have a situation where we see money going from the company to a creditor, we will attempt to avoid all of that money back. But that's sometimes wrong, because if the creditor has been providing goods and services, we can't claw back all of the money that the creditor got over that period. We can only claw back the net change in position. So let's say we go back to 2 years. If the creditor owed the company now in liquidation $100,000, but they owed $60,000 at the point of liquidation, it's only that last $40,000 that we can actually claw back. But Brent, you deal in a lot of situations, you're dealing now with creditors who are facing liquidators clawing the money back. And so what sort of approaches are you taking to defend creditors in that situation?
Yeah, so my interpretation of what most liquidators do is that it's a shakedown. So they issue these notices, they overstate their position, and they want a full payment of $100,000, but really it's only about $5,000 at risk. So with that assumption in mind...
how did you get such a terrible perception of insolvency practitioners?
Oh look, I've come across a few of them. So with that assumption in mind, what we do is we murky the waters as much as possible in relation to those three pillars of the defence. And most times we're telling liquidators, look, we're not paying anything. If you want to go to court on this, go to court.
And the reality is that I guess you would have a feel for the insolvency firm you're dealing with, you'd have a feel for which ones are going to litigate and which ones aren't.
Yeah. I mean, you also know by how much money is sitting in the bank account of the liquidator at the time they're making the demand, because if there's money sitting in the bank account, they're more likely to pay a lawyer. If there's not, then it's more likely it's just a bluff.
That's a terribly cynical approach to take the insolvency industry, but Brent might be correct. we go into a lot of these issues, a lot more of the defences and the history and how the regime works from a practical perspective in the longer video which is attached.